Thank you very much, Yeva, and thank you to the organizers for the opportunity to speak with you today about the Irish example of how we regulate lobbying. I have some slides to share with you, and I'll try to be brief. What I wanted to do today was to talk to you about the framework of the Act that we have in Ireland, how it works and how it's structured, as well as our own experience in terms of implementation and some of the lessons we've learned along the way. I hope that you'll find this helpful, and I'm happy to answer any questions you might have at the end of the presentation. So if I could go to the first slide, please. The framework of the Act is structured in a way that allows for an independent registrar. So the Standards in Public Office Commission, for which I work, is a fully independent body, separate from the government and separate from Parliament. And we are the ones that are tasked with the regulation of lobbying. The Act itself sets out a framework to ensure the registration of lobbyists or interest representatives. And the scope of that regulation is actually quite broad. It includes businesses, third-party registration, as well as advocacy groups such as charities and representative bodies, as well as people, any individual that lobbies about the zoning and development of land. So it's actually a very broad scope in terms of who might be covered by the legislation. It also provides that that returns of lobbying activity be submitted on a prescribed basis 3 times per year. That includes nil returns in the situation where there may not be lobbying in that particular return period. It's a web-based public registry, and it covers any persons who are communicating, as well as the subject matter and the intended result. And I'll talk a little bit more about that in a moment. The Act sets out post-employment cooling off restrictions for certain public officials. It's a 1-year cooling off period during which they're not allowed to lobby or be employed by someone who lobbies either their former public body or their former colleagues. This is probably the weakest feature of the legislation because there are no enforcement powers attached to that, but there are investigation and enforcement provisions attached to the rest of the legislation, which means if you fail to register or submit returns of your lobbying activity, or you fail to comply with a requirement of an investigation, then potentially you've committed an offense and you may be investigated or prosecuted for it. Finally, there's a review mechanism in the legislation. So every 3 years, the Act is meant to be reviewed by the government, and we would feed into that process and provide recommendations along the way. So if we could go to the next slide, please. Any communication must be registered if it meets what we call the 3-step test. And that means that the communication must be made by somebody who is within the scope of the legislation. Sorry, can we move to the next slide, please? I'm not sure if you can see the next slide on the page. It's what is covered, the 3-step test. So the communication must be made by a person who is within the scope of the legislation, and it must be made to a designated public official. So not all public servants are actually considered to be designated public officials for the purposes of the Act. It's generally the senior most people, the ministers of state, elected representatives, both at the national and local level, as well as senior civil servants within government departments and the local authorities. And finally, the communication must be about a relevant matter, which means that it has to be about a certain type of subject for it to count as lobbying. It won't count if somebody is just talking about the weather. It has to be about changes or amendments or the development of new legislation, policy, program, or some matter to do with the funding of an initiative or the award of a grant or a contract, anything to deal with financial matters. That would be considered a relevant matter as well. And then finally, anything to do with the zoning or development of land, which is a unique feature to the Irish legislation and specific to our own historical context in that regard. As was mentioned previously, the Act in Ireland is very interesting because it doesn't make any distinction regarding how a communication is made. If it meets the three-step test, it must be registered. And so that means that both formal and informal communications might be captured. It means that a casual encounter in a social setting could be counted as a lobbying communication, as well as the more formal meetings or letters or communications via email. Interestingly, social media could potentially be considered to be lobbying if a communication meets that three-step test, if it's directed at a designated public official and it has to do with a relevant matter. So, it's very interesting in terms of the range of communications that might be captured by the legislation. And we see that in the returns that are submitted on the register. You can see the breadth and scope of what might be considered to be lobbying. So the next slide, please. What is disclosed on the register is also quite broad. The identity of the person who is making the communication must be disclosed. And if it's a professional lobbyist who is communicating on behalf of a client, then the client's identity must also be disclosed, as well as identifying the person who's primarily responsible for making or managing or directing the communication. Any person who's targeted by the communication, meaning the public officials, must also be disclosed. So because it's one return per subject matter, it means that you might see on a single return numerous public officials named on a return, even though they might have been targeted by a single communication. And it's because we're trying to roll it up for administrative ease for the person who's registered. The relevant period or the dates that the lobbying occurred in must also be disclosed, as well as the subject matter of the lobbying and the intended result. Now, when we first introduced the lobbying legislation, this gave a little bit of difficulty, I think, for people to understand what exactly we meant by that. It's not sufficient for somebody to say, we wanted to raise interests or issues of interest to a designated public official. It's necessary for them to say, we were seeking a legislative amendment to this particular act, and what we wanted was X. Now, there are people who are registered that may not understand fully what we're looking for on a return and what's required for full transparency. In those instances, we contact them. We look at every return that comes into the system, and we will contact individuals or registrants if we believe that they haven't included sufficient information. And they are sent a further information request, and they can modify their return. So it's very important to us, and for the purposes of the legislation, that transparency is comprehensive and that people will disclose exactly what it is they're lobbying about. It's also important that they disclose the mechanism used. So you'll see on the returns whether a communication was made in a meeting or by telephone call or by a text. And there's also a mechanism to indicate whether a grassroots campaign was held. For example, if a charity is organizing an extensive campaign to try and shape a particular regulation or a particular law, or to seek funding, they might do a call to their volunteers and say, would you please all write to your local member of parliament? And it's the charity that must register those communications, not the grassroots volunteers. So those campaigns are disclosed as well. The frequency with which people are lobbying must also be disclosed. And we don't expect people will say, oh, I communicated 47 times, there were 47 texts, and there were 83 letters, and so on. It doesn't have to be that specific. We basically ask for an estimated range. If somebody had a single meeting, then they can select one. If there's 2 to 5 emails, fine. If there's 50 to 100 emails or letters, then that's fine too. So it's really about the range. We're not seeking for the disclosure of every single communication. It's to show the essential volume that's involved. And finally, if there's anybody who's involved in that lobbying on behalf of an organization that is either currently a public official or used to be one and they've retired, that must be disclosed as well. And that helps in terms of how people are influencing the decision-making process. It discloses the influence of people who are in power or still have the networks that are going to give them access to decision makers. Okay, the next slide, please. So in terms of how we approached implementation in Ireland, we did extensive pre-planning. We were involved on a consultative basis with the department that was developing the legislation. And I think that served a very useful purpose because we could say to them what was actually operational and what wasn't, how we could make something work effectively, and they could run it by us with our own experience regulating in ethics and political finance. We engaged with stakeholders very early in the process, and we had a project board, including members of the lobbying community or the potential registrants, to help us with user testing for systems development, as well as an advisory group in terms of our communications and how we sought to implement the Act. We developed the systems themselves very early, and in fact, we launched the register 4 months before the Act came into effect in order to allow for people to test the system and learn how it worked and submit fake returns just to try and figure out how the system actually operated. And it allowed for a prolonged learning period before the Act in fact commenced. We developed, in conjunction with that, we developed and launched our website, guidelines and frequently asked questions, and some help videos for people to understand how to register and how to submit returns. We implemented an extensive communications and outreach strategy. And when I say extensive, the first year of the lobbying registration system, I think I was on the road more often than I wasn't. We did something like 76 presentations in the first year, all across the country, up and down the country, and met with public officials groups as well as with potential registrants. And I think that was absolutely vital in terms of demystifying the process, making sure people understood what it was all about and why they should register and what the rules were. And I think it helped remove any concerns that people had over what the system was really supposed to do and how it would work in practice. Finally, we took an approach of incremental commencement of the Act in Ireland, whereby the main provisions of the Act came into effect on the 1st of September 2015. So it's been in force for just over 5 years now. But the enforcement provisions didn't come into effect until the 1st of January of 2017. So there was a full year, just over a year, before people had to worry about being penalized if they weren't actually compliant with the legislation. It allowed for people to make mistakes and get used to the mandatory registration deadlines and the fact that they had to submit returns on a specific date or by a specific date. And I think that that was really important for people to, be able to make mistakes without fear of penalty. Once the provisions came into effect, though, we maintained a compliance-focused approach. So we do have investigation and enforcement provisions at our disposal if they're necessary, but we try to encourage compliance in the first instance, and we try to achieve compliance. Where we can do that, we try not to proceed to prosecution. So we have proceeded to prosecution on a few occasions, and generally speaking have been able to achieve compliance right up to the last minute. So if we could move to the next slide, please. Some of the challenges that I would say there are in the legislation are the scope of the legislation itself, which is both an advantage and a disadvantage. One of the great strengths, I think, of the Irish legislation is that it really captures most lobbying communications, things that people would understand to be lobbying. And that includes, having a very broad scope of designated public officials at both the national and the local levels, and having such a wide range of potential registrants. That also meant, though, that we had a very big job ahead of ourselves to try and make sure people who were potentially subject to the legislation or involved, including public officials, heard about it. So we had to have such a big communications and outreach strategy in order to meet the needs of those groups. There were concerns of the public officials and the interest groups over the potential chilling effect of having regulation in place. And I've heard this from virtually every jurisdiction, that people think that once you've got a regulation in place, people won't lobby anymore, public officials won't hear from the groups that they need to hear from, and the doors will close. And that has not happened in Ireland, nor did it happen in Canada, nor does it happen anywhere. Lobbying is essential in terms of informing the public policy process. And there is no way that lobbying stops just because a regulation comes into effect. I think that it took probably the first 1 or 2 return periods for people to see that lobbying continued, and that it didn't really create any impediment to access. It did, however, make things transparent. That was the only change, and it was a change for the better. There were some growing pains along the way in terms of the quality of the returns. As I mentioned, people didn't really understand what level of detail was required, but over time that has improved immeasurably, and we continue to work with people and target people where their returns are perhaps not as compliant as they should be or not as detailed as they should be. So quality control has been an ongoing process for us. And we've also noted that some sectors of the economy perhaps were underrepresented, or some regions were not as well represented as we would have expected to see. And so we continue the outreach in those areas to try and make sure that we are reaching people that have obligations under the legislation, no matter where they are geographically in the country or which sector they belong to. What we've learned along the way is that a consultative approach has been really important in terms of supporting the wider acceptance of the legislation and ensuring that people will comply where they're required to do so. Ongoing communications are key. It's not just a question of doing a big push at the beginning of the lifetime of the legislation. It's important that you carry on with communications throughout and reach out to groups and organizations and new registrants who will come on board throughout the lifetime of the legislation, and other registrants will leave. So we have to carry on with our communications along the way. Incremental implementation, I believe, has allowed us to build trust with people. Having that first period where we were able to implement the legislation, but enforcement wasn't in place for about a year, I think really helped people realize that we weren't trying to catch anybody or trap anybody. It was really about trying to ensure transparency. And I think that that has helped in terms of ensuring people trusting the system and trusting ourselves as the regulator, that, in terms of the approach that we take. And ongoing quality control, as I mentioned, I think is important, and it ensures that we are learning from mistakes as well. We're not only helping registrants, but we're refining the language on the register. If something isn't clear, we're finding that we thought it was clear, but maybe it's not working as well as we thought. And we've also refined some processes along the way. So that's an ongoing process. We need to learn as an organization and as a regulator as well. The next slide, please. So results that we've seen to date have been really encouraging. The very first return period, we had about 1,000 registrants, which is extraordinary. And that has continued to grow. And we're now at roughly 2,100 registrants. And they come from all sectors of the Irish economy. That includes businesses that are generally medium and large sized, representative bodies, charitable groups, and advocacy organizations that are seeking to register, including, for example, Transparency International Ireland, which would be the counterpart organization for one of our hosts today. The financial services industry, communications consultants, third-party professionals such as lawyers, they're all on the register, really. And so that's gratifying to see that people understand and see themselves in the scope of the legislation, and they are complying. We also have a variety of organizations, mostly domestic, but we do have some multinationals and some foreign registrants on the register as well, which is terrific because it shows that they are complying with the spirit and the intent of the legislation and registering as they need to. At the moment, we have more than 47,000 returns on the register. We get probably around between 3,000 and 3,500 returns at every return period, and there's 3 a year. So the register grows by about 10,000 returns a year. And they are, of all areas in terms of areas of interest where lobbying is occurring. But the 5 most popular areas where lobbying is taking place is healthcare, economic concerns and industry, agriculture. Ireland is a very heavily agricultural society still, and so you can see how that features in the lobbying legislation. and justice matters and equality, as well as housing. This has not changed in terms of the era of COVID. We're certainly seeing a number of returns that deal with coronavirus and COVID and the supports that are going to be required for particular industrial groups, for example, or organizations that are lobbying for contracts. You would see a lot of COVID returns, or COVID as a keyword in a lot of returns that are showing up on the register. But those 5 areas, including health and industry, would have been top 5 all along. So it's always been very important, those particular areas. As I said, we do focus on compliance as our first priority, but we use enforcement as needed. So far, we've issued over 1,000 fines for late returns, and that's the only area where we fine directly. It's an administrative penalty, really. But if somebody commits a more serious infraction of the legislation, they fail to register or they fail to submit a return, then we can prosecute. And on a summary basis, they might be fined up to 2,500 euro. But if they're convicted on indictment, then the fine will be set by the court and there's no limit. And there's also potentially imprisonment for a period of up to 2 years. So having those enforcement tools in place is very important, I think, for the strength of the legislation. But we haven't had to implement them that frequently, really. So generally speaking, a push to comply tends to achieve the results we want. And then my last slide is on the impact of the register. So if we could move to that, please. What I believe the impact has been is really just to enhance transparency. There's now information available to the public that was never previously available. It's used by a number of organizations and individuals, obviously by journalists, but also by academia, non-governmental organizations, businesses themselves, which is interesting, and the government. We've been told that organizations are using it to, for example, keep an eye on what their competitors might be doing to try and ensure that somebody else isn't getting the access that they are not, and they can push for access when they see that some other side of an issue might be getting access. And it's often used in conjunction with freedom of information legislation, which is interesting. So a journalist might see something on the Register of Lobbying where an activity took place, and then they will submit a freedom of information request to the policy department or to the minister to get the other side of the information, to get any documentation that's associated. I think that this is part of a very interesting growing trend towards regulation in this area. There's a lot of organizations that are pushing for regulation, but we've seen a number of countries across Europe now moving in this direction, which is terrific and very good for openness in society, I think. And, you know, I think that Ireland has certainly sought to help wherever possible based on our own experience in terms of any lessons we've learned, and try to encourage the development of lobbying regulation. And then finally, I think it's pushed for better balance in policymaking. I don't have any statistics on this, it's anecdotal largely, but you know, organizations are using this to grow their business, certainly, to monitor their competition. But more importantly, I think that it's been used in order to force balance among the public official community. If it's being made public that they are meeting with one side of an issue, it doesn't look as though they're hearing from everybody they need to hear from. And so I think it's forced the public officials to make sure that they're hearing from a broad range of views, and that can only be better for policymaking. So that's the end of my presentation. I'm happy to take any questions that anybody might have, either now or at a later time. And I wish you the very, very best as you move in this direction yourselves and begin the process of regulation. Thank you for your time.